You're watching The Legal Breakdown. So, Glenn, we've got some troubling news out of Georgia where Trump is awaiting trial in a major racketeering case that's a criminal case out there. It seems that 3 of the charges against him were dropped. Can you explain what happened?
Yeah, so I think 3 of the 10 charges against Donald Trump were dismissed by Judge McAfee. This is something of a surprise move, but I read Judge McAfee's 9 or 10-page order, and it actually kind of makes perfect sense. What I think is most important for people to know is this is what I would call a technical defect in the indictment, and importantly, one that can be corrected such that all of the charges that were just dismissed can absolutely be reindicted and can be incorporated into this case again. But in substance, let me try to break down what happened here. Basically, when you're indicted on a criminal charge, the indictment, that is the language that sets out what you did, the crime you committed, has to include information about all of the elements of the crime. Judge McAfee said for some of these charges of soliciting government officials to violate their oath, he found that there wasn't precise enough information included in the indictment, in the charging document, to satisfy the constitutional requirements. What are those requirements? They're basically twofold. One, a defendant has to be put on adequate notice of what he or she must defend against. So there has to be certain language in the indictment, in the charge. And 2, it has to protect the defendant against double jeopardy, against being tried for the same or similar conduct if the language in the indictment is too vague. So this is, I don't often call things technicality. So, for example, when evidence gets thrown out of court because there was police misconduct or prosecutorial misconduct in violation of a defendant's constitutional rights, you will never hear me say that got thrown out on a technicality. But this really is a technicality, and one that can be remedied moving forward. And Judge McAfee, in his ruling, actually set out precisely how it can be remedied moving forward.
Well, why go to the step of dropping the charges then? Why not just give prosecutors the opportunity to rectify what is essentially just a technical defect in the indictment?
Yeah, that's a great question, and I'm going to expose myself as the law nerd I am, Brian, because it's all about the footnotes. I think it's footnote 8, I could be wrong about the number, Judge McAfee answered that question. He said, listen, other jurisdictions, for example, the federal government, handles this much more efficiently. All they have to do is file an additional notice pursuant to what's called the Bill of Particulars, and they can remedy this sort of technical shortfall. But he said the laws of Georgia don't have comparable provisions, so we have to do it in a way that will take much longer. More precisely, the prosecutors will have to do it in a way that will take much longer. So he actually answers that precise question.
Well, is it possible for these charges to come back in this same indictment, to be included in this same racketeering trial, or does it have to be brought in a completely separate trial?
Yeah, also a good question. The same trial, and we could talk about whether it's the same indictment or a different indictment, and that's sort of beside the point. You can do it one of 2 ways when you're a prosecutor and you have to go back to the grand jury and get an additional indictment for any number of reasons. You can do it one of 2 ways. You can do what's called a superseding indictment, which means you're going to add new charges, including charges that were just dismissed, to the initial indictment and return one indictment anew, or you can return what's called a satellite indictment and then make a motion to join it to the original indictment. Those are 2 slightly different procedures that prosecutors follow to bring additional charges in a case for any number of reasons. But I think what's going to happen down in Georgia, reading kind of this motion and the footnotes, Judge McAfee said, look, prosecutors, I'm going to extend by 6 months the time from the date I issued this order dismissing these 6 counts. I'm going to give you 6 months to go back into the grand jury if you choose, re-indict these charges properly, and that will do away with the deficiency that just led me to dismiss them in the first place. Brian, here's what Judge McAfee is doing. He has been a thoughtful judge every step of the way, as best I've been able to tell, and I've been watching him pretty closely, in part because these proceedings are televised, which is a very good thing. What he's doing is he's protecting the record. The last thing you want to do is go to trial, win convictions, and then have it work its way up through the appellate courts, only to have some appellate court judge say, well, wait a minute, there was some deficiency in the way the way the case was charged, in the language that was included in the indictment. And then what happens is you have to overturn the case, send it back to the trial court, and you have to start over from jump with a brand new trial. Judge McAfee is troubleshooting. He's applying the somewhat unique laws of Georgia to what he's seeing. And based on everything I'm seeing, he continues to call it right down the middle.
Okay, so with all of that said, you're confident then that the same number of charges that were pending against Donald Trump prior to this week will ultimately be pending against him at the end of this whole remedy process?
I am. And let me quote one line from Judge McAfee's order, which I really like and frankly appreciate. He says, first of all, he says, make no mistake about it, I'm not dismissing the indictment. He says that in a footnote. And then he actually tries to highlight the fact that this is more about form and less about substance when he says, the court's concern is less that the state, that means the prosecutors, the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In other words, that they actually committed crimes. He says, in fact, the prosecution has alleged an abundance of conduct by the defendants that qualifies them for this prosecution. It really is about the form that those charges take, not the substance of the evidence against the defendants. I've teased that out a little bit, but it's pretty unmistakable that he's trying to send the signal there in his very carefully chosen words that this is about form, it's not about substance, and I'm not permanently throwing anything out because this sort of technical misstep can be fixed.
Okay. Glenn, going to a different element of this case, we did see a bunch of flips all at once, and that was, with Sidney Powell, Kenneth Chesebro, Scott Hall, Jenna Ellis, and then things seem to have slowed to a stop. Why might that be?
Hard to say. I've handled large RICO conspiracy cases with dozens of defendants. We're generally able to whittle it down to sort of less than the 15 defendants we still see, holding fast, hanging tough down in Georgia. I fully expect that negotiations continue with any number of the defense attorneys representing the 15 remaining defendants of the 19 that were originally indicted. But I am surprised. I'm a little surprised we haven't seen more dominoes fall, particularly after those first 4 defendants chose to plead guilty. And let's face it, 3 of the 4 were in the upper echelons of this conspiracy, right? Because it was Sidney Powell, one of Donald Trump's lawyers. It was Kenneth Chesebro, the architect of the fake elector scheme. It was Jenna Ellis, somebody who was sort of shoulder to shoulder with Rudy Giuliani when he was filing all these baseless lawsuits attacking the results of the 2020 election. So because those are some of the real marquee defendants who decided to plead guilty and cooperate, testify against Donald Trump and the others at the future trial, I am a little surprised we haven't seen more dominoes fall, more defendants come in, plead guilty, and agree to cooperate. But listen, this case, Brian, was not built for speed. This was built as a comprehensive vehicle to hold everybody that Fani Willis believed the evidence showed was involved in that conspiracy to overturn the results of the Georgia state election for president. And so this is not a sprint by any means. This is a marathon that, frankly, we could see tried well into 2025, even into 2026.
Well, then that raises the question, what happens in the event that Donald Trump becomes president and this case was never, built for speed, to your exact point, and it's ready to go to trial in the middle of 2026, which would be like a year into a potential second term for Donald Trump? What actually will happen to the prosecution?
Yeah, in the horrific event that somebody who is an avowed dictator on day one becomes president again, I think all bets are off, including Americans' opportunity to ever vote in a future election, because the man has said, I'll be a dictator on day one. So, this prosecution may end up being the least of America's problems. But to your question, I assume what he will do if he gets reelected is he will try to have his lawyers, his Department of Justice, his White House counsel's office assert a sort of supremacy clause argument. Because the federal government is supreme, that's not exactly what the supremacy clause stands for. What it stands for is when there's a conflict between the laws of the state and the laws of the federal government wins out because it's supreme. It is kind of over and above the state jurisdictions. But he'll make a modified supremacy clause claim saying, hey, states can't touch a sitting president. I have no idea, Brian, how receptive courts will be to that argument. They shouldn't be all that receptive because we all know Donald Trump is trying to delay his way out of criminal trials, criminal convictions, and ultimately he's trying to delay his way out of a prison cell. But it's a wide open question as to how the courts will receive a supremacy clause attack if Donald Trump is elected and he tries to put a stop to the state court prosecutions, both in Georgia and in the event the New York case is still pending, which it ought not be because it's scheduled to go to trial on March 25th. But if it is, you can bet he'll try to put a stop to that one by hook or by crook.
And let's finish off with this. You'd mentioned earlier that Judge McAfee had given the state 6 months to remedy this technical defect in with those three charges. So to that point, can you give an update on what you think the timeline looks like for this case to actually go to trial, considering they've already gotten a 6 month lead time for just remedying one small issue? So what are we looking at in terms of an actual trial date?
Yeah, I can't even spot a viable trial date on the horizon at this point for the Georgia prosecution. Here's why. One of the three charges that Judge McAfee just dismissed and gave the prosecutors the opportunity to get back before the grand jury and re-indict it using proper language involved that phone call to Brad Raffensperger by Donald Trump, just find me 11,780 votes and corruptly declare me the winner. I don't think that's a charge that Fani Willis and her team are willing to forego. So I think they're going to get back to the grand jury. I think they're going to take a few months to re-indict the case, doing away with these technical problems, and then get back on the trial track. But I'm not even going to venture a guess as to how soon all of that can be accomplished and then have the case actually set for a realistic trial date.
Well, look, for those watching right now, Glenn and I will, of course, stay on top of all these trials for as long as they take to actually move forward, with the quickest one being within the next couple weeks here in Manhattan. That's the trial beginning on March 25th. So for those watching right now, if you want to follow along with all of these trials, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.